1818. London. A young man stood in court, accused of murder. He threw down a leather gauntlet and demanded trial by combat, to the death. With the brother of the woman he was accused of killing. The court said yes. The year was 1818, not 1218. Napoleon had already been beaten at Waterloo and exiled to a rock in the South Atlantic. Gas lamps were going up on the streets of London. Steam engines were pulling coal out of the ground in the north. Jane Austen had just died. The first public railway was 8 years away. This was modern England, or as modern as England gets, in the Regency. And the judges of the King's Bench, the highest common law court in England, sat there in their horsehair wigs in the year of our Lord 1818, and realized slowly, with a dawning institutional horror, that they were going to have to allow it. This is the story of Ashford versus Thornton, the last successful invocation of trial by combat in English common law. The case that forced Parliament to dig through its own statutes and quietly admit that the law had been sleepwalking for 600 years, past a door it had forgotten to close. This is the moment English law became ashamed of itself. Before we go any further, we need to say who Mary Ashford was, because the legal mechanism that made this case famous is the thing we are going to spend most of this video unpacking. But none of it begins without her, and the absurdity that follows is not hers. It belongs to the courts, the statutes, and the men in wigs. Mary Ashford was a young woman, 20 years old. She lived in Warwickshire, in the English Midlands, not far from a place called Sutton Coldfield. She worked, by all accounts, as most young women of her station worked in 1817. Domestic service, long hours, modest wages, a respectable life, with very little margin for error. On the evening of the 26th of May, 1817, she went to a dance. It was a Whit Monday dance, an annual event, the kind of local gathering where young people from surrounding villages met one another. She danced. She stayed late. At some point during the night, she left the dance in the company of a man she had met there. His name was Abraham Thornton. He was 25, a bricklayer's son, locally known, not particularly well regarded. What happened between them, in the hours after they left the dance, is the central unknowable fact of this entire case. What is certain is this. Early the next morning, the 27th of May, 1817, Mary Ashford was found dead in a pit of water near Penn's Mills in Sutton Coldfield. A coroner's inquest was held. On the 30th of May, the jury returned a verdict of willful murder against Abraham Thornton. He was committed for trial. The allegations against him were grave. The Count later filed in. The appeal accused him of sexual assault, followed by drowning. We are not going to dwell on those allegations in this video. They were contested at trial. A jury heard the evidence. And on the 8th of August, 1817, at the Warwick Assizes, in front of Justice George Soley Holroyd, Abraham Thornton was acquitted of murder and of the associated charge. He walked out of Warwick a free man. This is where, in any ordinary case, the legal story ends. A trial has been held. A verdict has been returned. The accused is either hanged or released. The state, having exercised its monopoly on prosecution, steps back. The family of the deceased is left with whatever grief and whatever doubt the verdict has failed to resolve. And the law, having done its work, goes quiet. But 1817, England was not quite done with Abraham Thornton. And Abraham Thornton, it would turn out, was not quite done with the law. Because there was another door, an older door, a door so old that most of the lawyers in London had stopped checking to see if it was still unlocked. And in the weeks after that, Warwick Acquittal, somebody, a lawyer, a pamphleteer, or perhaps William Ashford himself, Mary's quiet brother, reached for the handle, and the handle turned. To understand what happened next, you have to understand a piece of English law that by 1817, almost nobody believed was still real. In the English common law of the early 19th century, there were two ways a man could be tried for murder. The first was the one we recognize. The Crown, meaning the state, brought the prosecution. A grand jury decided whether there was enough to go to trial. If there was, a trial jury heard the evidence. A judge presided. If the accused was convicted, he hanged. If acquitted, he walked, and the verdict, whichever way it went, was meant to be final. The second way was older, much older, and by 1817 it had been so rarely invoked that most practicing barristers had never seen it. It was called an appeal of murder. The first was the one we recognize. The Crown, meaning the state, brought the prosecution. A grand jury decided whether there was enough to go to trial. If there was, a trial jury heard the evidence. A judge presided. If the accused was convicted, he hanged. If acquitted, he walked. And the verdict, whichever way it went, was meant to be final. The second way was older, much older. And by 1817, it had been so rarely invoked that most practicing barristers had never seen it. It was called an appeal of murder. Despite the name, it was not an appeal in the modern sense. It was not a higher court reviewing a lower court's verdict. It was something else entirely. It was a private criminal prosecution, brought not by the Crown, but by the nearest heir of the deceased, usually a son, a brother, or a widow. A person with a blood interest in seeing the killing answered for. An appeal of murder survived the defendant's acquittal. That is the key detail. It was a second bite at the apple, available to the family of the deceased if they believed the Crown had failed. It did not care about double jeopardy in the modern sense. It existed precisely because, in the medieval imagination from which it descended, murder was a private wound as much as a public one. The family had a right to answer for their dead. By 1817, this procedure was a legal relic. It had not been used successfully in anyone's living memory. It sat in the books like an old family sword above a fireplace. Still there, still sharp. But nobody actually expected it to come down from the wall. The acquittal of Abraham Thornton brought it down. The acquittal was unpopular. That is an understatement. The acquittal was the kind of verdict that does not stay inside a courtroom. It leaked out of Warwick and into the streets. It was carried by coach to London. It was printed in the papers. It was set into the leaded type of pamphleteers who made their living on Regency crime. John Fairbairn, a London printer, produced a pamphlet that year with a title long enough to be its own article, The Affecting Case of Mary Ashford. And it sold. Other printers followed. Cheap broadsides went up in taverns. Ballads were written. In the theatres of London and the provinces, dramatists were already sketching out plays based on the case. Fictionalized, renamed, but unmistakable to anyone paying attention. The academic David Worrell, writing almost 2 centuries later, would catalogue a full genre of Mary Ashford drama that emerged in these months. Plays with names like The Mysterious Murder and The Murdered Maid. It was, in the language of the day, a sensation. And the sensation had a shape. It was not a general sympathy. It was a specific, directed, almost architectural public certainty that the wrong verdict had been returned at Warwick. Into this climate stepped William Ashford. William was Mary's brother. The historical record leaves him as a thin figure, not a lawyer, not a public man, a brother, the heir, in the old technical sense that the appeal of murder required. He was the one, and only, person in England with the legal standing to reopen the door that the common law had left hanging on its hinges. And on the 1st of October, 1817, a writ of appeal of murder was issued in his name against Abraham Thornton. The language was medieval. The procedure was medieval. The right was medieval. But the writ was real. And Thornton, who had been walking free for less than 2 months, was suddenly a defendant again. On the 10th of October, he was taken back into custody. Under a procedure his lawyers had, until very recently, been sure was dead. You can almost feel the mood of the public at this moment. There is a sense, in the pamphlets, that justice has cleverly reopened itself. The appeal of murder looks, from a certain angle, like a second chance. The jury at Warwick is not going to get the last word. A new court will hear the case. A new verdict will be returned. The rumour-fed certainty that filled the streets of London and Birmingham will finally have its day in a courtroom. That was the hope. Nobody yet understood that when you drag a medieval procedure back into a modern courtroom, you do not get to choose which parts of it you bring with you. You get all of it, the good and the absurd, the useful and the embarrassing. Because the appeal of murder did not travel alone. It had a companion, a shadow that had ridden beside it since the Norman conquest. And as William Ashford's writ made its slow way through the papers and into the hands of Abraham Thornton's newly retained London lawyers, those lawyers were doing something unusual. They were sitting in a library in the Inns of Court, reading very old books, looking very carefully at a procedural right that had travelled with the appeal of murder the whole time, and planning to throw down a glove. On the 16th of November, 1817, Abraham Thornton was brought into the Court of King's Bench in Westminster Hall to answer William Ashford's private appeal. Westminster Hall, in 1817, was already an old building. The hammer-beam roof above the court was almost 400 years old. Kings had been tried in this room. Regicides had been sentenced in this room. The bench at which the King's Bench sat was worn dark by centuries of robed elbows. The air smelled of candle smoke and damp wool. Thornton was placed at the bar. The charge was read. He was asked how he pleaded. He spoke the answer that his counsel had prepared for him, and which the counsel had found, after weeks of digging in the old reports and older treatises, that most practising lawyers of 1817 had never bothered to open. He said, in open court, the words, "Not guilty, and I am ready to defend the same by my body." And he drew from his person a leather gauntlet and let it fall to the floor of the court. There is no surviving account of what the courtroom did in the seconds after. The transcripts are legal transcripts. They record the plea, and they record the gauge. They do not record silence. But you can, if you want to, try to imagine it. The Lord Chief Justice of the King's Bench, at that moment, was Lord Ellenborough. Although by the spring of 1818, he would be succeeded by others on the bench during the argument. The judges on the bench had between them more than a century of combined legal experience. Not one of them had ever seen a man in a dock, in their presence, throw down a gauntlet and demand to settle a criminal charge by personal combat. They had read about it in Bracton, in Glanville, In the old yearbooks of the Plantagenets, they had studied it in the way modern lawyers study the quill and the wax seal, as a thing that had once existed, as a piece of legal archaeology, not as a live right. Thornton's counsel, however, had read more carefully, and what he had found after weeks in the library was this: trial by battle. In legal Latin, wager of battle had never been abolished, not by Parliament, not by any court. It had simply fallen out of use. Disuse was not repeal, and the common law did not, in its own theory of itself, lose rules because people stopped invoking them. The gauntlet on the floor of the King's Bench was a legal argument. It said, in one gesture, "You cannot refuse me this, because nobody ever took it away. So we have to explain what wager of battle actually was, because it is not what modern viewers think it is. This was not a duel. This was not two men firing pistols at dawn for honor. This was an older and more ritualized thing, and it had its own rules. It had been brought to England by the Normans after 1066. In its original form, it was available in certain criminal and civil proceedings as a mode of proof, meaning, instead of juries and witnesses, you could settle the truth by seeing who God allowed to win. The theology was specific. God would not permit the wicked party to triumph. The outcome of the fight was the verdict. In a criminal appeal, the procedure worked like this. The appellee, the accused, would plead not guilty and offer his body in defense of the plea. He threw down his glove. If the appellant, the accuser, chose to proceed, he picked the glove up. The two men were then marched to a field, an enclosed space, 60 feet square. They fought, on foot, with staves and leather shields, from sunrise to sunset. If the appellant won, the appellee was hanged on the spot. If the appellee won, or if the appellant simply failed to defeat him before the stars came out, the appellee was acquitted, forever, no further prosecution. The verdict of the field was final. If the appellant refused to pick up the glove at all, that was the end of it too. The appeal collapsed. The appellee walked free. You can already see, even without knowing what happened next, what Thornton's counsel had understood. William Ashford was not a fighter. He was a slight man, a labourer, not physically formidable. Abraham Thornton, on the other hand, was a bricklayer's son, strong, 25 years old, in full health. If the court of King's Bench ruled that wager of battle was still legal, William Ashford faced three choices. He could fight Abraham Thornton with medieval weapons for an entire day, to the probable death of one of them. He could refuse to fight and watch Thornton walk free a second time, or he could hope that the judges would find some way to bar the wager and force the case back onto its regular track. The first option was suicide. The second option was surrender. The third option depended on whether the judges of the King's Bench, in the year 1818, had the legal courage to reach into the common law and tear out a page. The arguments would take 5 months. The legal argument in Ashford v. Thornton was heard, in the main, over several days beginning in early February 1818. Joseph Chitty, one of the most respected legal writers of the era, appeared for William Ashford. Thornton was represented by able counsel who had clearly done their research. What was being argued was not, at its surface, whether trial by battle was a good idea. Nobody in the courtroom believed it was a good idea. What was being argued was something narrower and more uncomfortable, and in the end, more honest. Had trial by battle ever actually been abolished? Chitty, for Ashford, did not try to say it had. He could not. The books were clear. There was no statute, no decision, no formal act of the legislature that had put wager of battle to death. What Chitty tried to do instead was more subtle. He tried to argue that this particular case was not a proper case for it. Under the old rules, the right of wager of battle was not absolute. There was an exception. If the appellant could plead a specific kind of evidence against the appellee, evidence so overwhelming, so direct, so conclusive, the appellee could be denied the wager. The phrase the old authorities used, and which the King's Bench would have to interpret, was that the evidence had to be such that the presumption of guilt was so violent and so strong that no possible doubt remained. No possible doubt, not reasonable doubt, possible doubt. Chitty filed a counterplea, listing the evidence that had been assembled against Abraham Thornton. The circumstances of the evening, footprints near the pit, the condition of Mary Ashford's body when it was found, the timeline that placed Thornton in her company in the hours before her death. It was, in a modern criminal trial, a substantial case. It was the reason the Warwick jury had come so close to convicting. It was the reason public opinion in England was, by the spring of 1818, almost unanimously against him. But it was not the standard the common law of wager required. On the 16th of April, 1818, the Court of King's Bench delivered its ruling. The court had found, as a matter of law, that wager of battle was still a legal right of the appellee in an appeal of murder. It had found, as a matter of law, that the right could only be ousted by a counterplea showing presumptions so violent and strong that no possible doubt remained. And it had found, as a matter of law, that Ashford's counterplea did not meet that standard. Suspicion was not enough. Strong suspicion was not enough. Circumstantial evidence, however compelling, was not enough. The court was not saying that Thornton was innocent. It was not saying that William Ashford's case was weak. It was saying something more narrow, and in its way, more damning. It was saying that the common law, as the common law stood in April of 1818, still contained the right of wager of battle, and the Court of King's Bench had no lawful power to refuse it. Thornton could fight, or William could walk away. 4 days passed. On the 20th of April, 1818, William Ashford appeared in court and declined combat. He did not pick up the glove. There was no practical alternative. To fight would have been to die. And the case, under the ancient procedure that had just been ruled still alive, collapsed the moment he refused. Abraham Thornton was discharged from custody. He walked out of the King's Bench a free man. For the second time, the second acquittal was, in the eyes of the common law, as complete and as final as the first. A broadside printed in Nottingham that week by the firm of Shorrock and Son set the decision of the judges in black letter, type under a title, plain enough to be read from across a room. The appeal of murder. The decision of the judges in the case of Ashford versus Thornton. It was sold for a penny on street corners. It was read aloud in public houses. It was pinned to the walls of taverns, the way modern people share screenshots. The mood it produced was not pleased. It was not relieved. It was furious. The English public had watched in real time a court in its own capital reach into a medieval law book and allow a man suspected of murder to walk free because his accuser was not willing to kill him in a field. It did not matter how carefully the judges explained that they had followed the law as they found it. From the outside, what had happened looked very simple and very damning. A murderer, or a man that half the country believed was a murderer, had escaped by the legal equivalent of magic words. The press was merciless. Pamphlets multiplied. In 1818, Edward Augustus Kendall published a legal argument whose full title was itself a small polemic, an argument for construing, largely the right of an appellate of murder, to insist on trial by battle, and also for abolishing appeals. Kendall was not defending the ritual. He was making the case that if the courts were going to allow this kind of humiliation to happen, Parliament had better do its job and pull the sword down from the wall. Parliament was already listening. The bill moved through Parliament with a speed that is, for anyone familiar with the pace of English legal reform in the early 19th century, genuinely unusual. It had an official name, an act to abolish appeals of murder, treason, felony, and other offences, and wager of batel, or joining issue and trial by batel, in writs of right. It had a citation that lawyers still use today. 59, George III, Chapter 46. It received royal assent on the 22nd of June, 1819. 14 months after William Ashford had walked out of the King's Bench without picking up the glove. The Act did two things at once. Neither was an accident. It abolished by name appeals of murder, the private criminal prosecution William had brought. It abolished by name wager of battle, the medieval combat Thornton had demanded. And it did so with the language of a Parliament that had decided, after some months of reflection, that it would prefer not to be humiliated a second time. The statute was effectively a tidy-up, a recognition that the common law, left entirely to itself, could sometimes sleepwalk into absurdity, and that Parliament existed partly to wake it up. There is a legal concept, not in those words in 1819, but well understood since, that explains why Ashford v. Thornton matters more than a Regency legal curiosity. It is sometimes called, in modern writing, the problem of the zombie law. A zombie law is a rule that survives not because anyone defends it, not because anyone believes in it, not because it serves any purpose, but because nobody ever got around to formally repealing it. It exists because law, once written, does not simply evaporate when the culture that produced it moves on. It requires an act to kill it, and if the act is never performed, the law continues, technically, in force, waiting, dormant, for someone strange enough or desperate enough or clever enough to invoke it. Ashford v. Thornton is the cleanest example of the zombie law in the history of English common law. Wager of battle was not defended by anyone in 1818. The judges did not admire it. The public did not demand it. The lawyers who dug it up did so specifically because they knew it was dormant, and they knew a dormant rule in the common law is still a rule. The only thing standing between medieval combat and a 19th century courtroom was a single statute that had never been written. 18 months later, it was written, and the sword came down from the wall. Modern legal systems still run into zombie laws, small ones usually. A 19th century municipal ordinance that was never repealed and is still technically enforceable. A blue law in an American state forbidding some activity nobody performs anymore. A clause in a colonial statute that a post-colonial legislature forgot to strike. These are usually harmless, and they are usually invisible, until some lawyer, the way Abraham Thornton's counsel did in 1817, pulls one down from the shelf and argues that it still, in some uncomfortable way, applies. The law does not forget. The law only accumulates. Somebody has to clean up. Parliament in 1819 cleaned up. But there is one more thing, and we would be lying if we did not say it plainly. The case is usually told in legal histories and in podcasts and in videos, very much like this one, as a story about the absurdity of trial by battle, about the embarrassment of an 1818 courtroom, about the moment a modern state was forced to admit that its own rulebook still contained a door into the Middle Ages. That is the legal story. It is the story we came to tell. But there is another layer that sits underneath all of it, and it belongs to Mary Ashford. Because Mary Ashford was, before she was a case name and a pamphlet title, a 20-year-old woman in Warwickshire who went to a dance on a Monday evening in May and was found dead before the next morning. Her family never received a verdict that satisfied them. Her family never received anything that the English language would recognize as justice. The first trial returned an acquittal, and the second proceeding collapsed on the floor of a courtroom when the law refused to be anything other than what it had always been. The 1819 reform did not fix that. A statute cannot fix that. What the 1819 reform admitted, quietly, by striking out both the private appeal and the wager of battle at the same time, was something harder. It admitted that the old procedure, the one that had promised the family of the deceased a second chance, had never really been a chance at all. It had been a trapdoor, and it closed the trapdoor not because it had been used to cheat Mary Ashford's family, specifically, but because it was the kind of door that would cheat somebody else, eventually, in a way nobody could predict. Acquittal, in a system of human courts, is not innocence. It is the limit of proof. That is all it has ever been. It is the point at which the law, which cannot read minds, admits that it does not know what happened and declines to punish on a lesser certainty. The 1819 reform was English law admitting something about itself. Not that it was wrong about Abraham Thornton. The law was never going to say that, and it did not need to. But that it had been carrying, for 6 centuries, a piece of procedure that made a mockery of the question the family of a murdered person actually came to court to ask, which was, and always is, the same question. Tell us what happened to her. The law, in June of 1819, quietly admitted it could not always answer. Abraham Thornton, for his part, left England not long after. He is said to have emigrated to the United States. He lived out his life there, in obscurity, and the historical record loses him among the thousands of Regency emigrants who crossed the Atlantic in the decades after the Napoleonic Wars. William Ashford disappears back into Warwickshire and into silence. There is no record of him ever speaking publicly about the case. There is no record of him marrying. He outlives his sister by decades, but the books do not tell us, in the end, what he thought about any of it. Trial by battle, in the English common law, was never again invoked after 1819. In 2002, a British man named Leon Humphreys attempted, in jest, to demand trial by combat over a £50 traffic fine. A magistrate declined. Humphreys was cited under the 1819 statute. The sword, once down, stayed down. Ashford versus Thornton, 1818. The last time English law let a man escape a murder charge by demanding a duel. And the moment, quietly, that English law grew up. A new episode of Accidentally Illegal every Friday.